Okay, then good afternoon, everyone. We had planned to start our webinar for today at 3 p.m. So thank you very much for sharing part of your time and your day with us in the middle of your day. My name is Antoine Jouet, and I'm a French partner at Fidal, a full-service law firm, and I'm currently based in Lyon. It's a real pleasure to welcome you to our fourth webinar session, at least for the labor employment team, who will have the pleasure to introduce you to the topic today. We had decided to start webinar sessions on international topics and giving you practical tips and traps in an international context, because we have the chance to have some specialists in our panel today. We will have 1 hour. The 10 last minutes will be dedicated to some questions you may have. Do not hesitate to raise them during the webinar, but as your microphone are on mute or should be on mute, we will see them in the Q&R tool that you can use to raise your points. Who are we at unyer? We are a global organization of leading international professionals, service firms with an exclusive approach, accepting only one member firm for each jurisdiction. So this is a bit of a unique model. unyer itself is not a law firm, but a network currently made of 4 law firms, namely Luther in Germany, Fidal for France, Pirola, Penuto Dei and Associati in Italy, and KWR for Austria. So this is an original model network, but each firm remains independent, and we have some correspondence in other countries. So we are currently covering 14 countries, and we have more than 2,500 lawyers and advisors. So in a global world, clients need global solutions, and this is what we aim to achieve at your service. Our firm are covering traditional and main, apart from employment services, we are covering business law, corporate, contract, commercial law, tax, IPIT, litigations, advisory solutions, notary in some countries. So do not hesitate if you have any question. During our last webinar, for example, in February 2024, we focused on employment aspects on whistleblowing and inquiries. Then for the second round in September, or the third round in September, we explored in more details how to conduct internal inquiries in an international context. For today, we will cover the question of freelancers, platform workers, EOR, for those who are not familiar with the concept of EOR, and employees, as always, trying to inform you about the tips and traps in an international context. You might have been confronted to some situation where you come at your desk. For example, you have recently started as a chief human resources for EMEA in a group. The group has expanded its international activities in and outside EU, and you have various individuals working in some companies, subsidiaries, using different forms of contracts and kind of work, and you want to have an overview on the tips and traps for those possible situations that you are facing. We have been confronted in our daily life to some clients who are looking for some practical advices on how to structure and best to structure employment situation. And this is what we are trying to cover today. So for the panelists, we will try to cover with Nina and have an overview of possible options and possibilities. The do's of don'ts with Caroline and Xavier at Fidal when managing freelancers or service providers. We will then have Ottavio, Marco, and Rafael covering international freelancers and employees and employers of record. And then Anna will try to summarize you with and to cover the EU directive on platform workers. So I'm very pleased to introduce you with Nina, who will start with an introduction of the various possibilities and options you will have in employing service provider or other workers.
Thanks, Antoine, for the introduction, and hello, everyone. Let's just jump right into the case and take a look at the different types of contract. And in doing so, let's take a closer look at the options that are available in order to ensure an adequate supply of workforce for the company. So what are the main options in terms of supply of workforce? In essence, we have three options, and thus three types of contracts, although there are various contractual contract options, especially for one of the options. Which options I refer to? The employment of own personnel, so the employment contract, where you can find permanent contracts, fixed-term contracts, full-time contracts, part-time contracts, and well, it's the most common way of covering staff needs. What are the other options? The other option is the use of agency workers or personal leasing, and the use of freelancers and subcontractors. And maybe you will ask you, which is the right one, the right option for me? It's not a question of right or wrong. It's at least not if you use the options correctly, which I will discuss with you a bit more in detail in a moment. And of course, all of the options have their pros and cons. For example, the employment of own staff, the most common option, you have, and that's a really benefit, a stable HR planning, although you have to deal with ill employees who are on vacation, but you can plan, and planning is always a good for the company. In addition, own employees have a deeper knowledge of the company. They know what you need. You know what is important for the company. They know the structure, and in what is also important and a benefit from own employees, you can give them instructions. What is the difference to freelancer? Because freelancer are in case of freelancer, you're not able to give them instruction when you don't want to risk bogus self-employment. But employment of own staff has also its cons, because you are not so flexible. You have fixed financial burdens. You have legal obligations like paying social security insurance, have working conditions to met by statutory law. And all employees, when they employed more than 6 months, are protected against dismissal by law. And one of the problems you also have, it's quite difficult to find expertise at the moment at the market. So it's often not quite easy to find own staff. In contrast, using temporary workers or freelancers, that offers you flexibility, because you're not bound to specific legal obligations if you do it right. So the social insurance will be paid by the employer of the temporary worker, and if a freelancer is a freelancer, there are no social security obligations for the employer. And it's often easier to find expertise and specialists at short notice. However, it's often more expensive in a long way, and you have considerable legal and financial risk if you're not careful in using these both options. What is the main difference between temporary workers and freelancers, you may ask you? The difference between temporary workers and freelancers is that you can use temporary workers like your own employees. You can integrate them in your structure. They can work alongside with your own employees, while freelancers, on the other hand, are defined by the fact that they do their work independently without your supervisions. And if you supervise them, there's a high risk that they are bogus self-employed. What this will mean, I will come back to in a moment. In conclusion, for the basis, it's good to have your own staff. But to work with freelancers can be useful as well, especially if you have short-term projects, or you have projects where you need specific specialists, or also you have a scope of work or responsibilities you can clearly define and probably want to outsource, while temporary workers are useful for covering short-term and temporary staff needs. That said, using temporary workers and freelancers is not without risk. So what do you need to keep in mind? And here is where it gets tricky. While the use of temporary workers, you need to focus mainly on being compliant with the formal requirements. While when you use freelancers, it's quite important to have a look on how the contractual relationship is lived out. This means that when using temporary workers, it's important to pay a close attention to the contract and the contractual relationship, while working with freelancers is important to pay close attention how they perform their work and if they are really free. And please note in that context, if a freelancer is a freelancer or probably bogus self-employed, is usually determined by the authorities. And the authorities do an overall assessment and it's assessed case by case. So you need to look in every factors. What exactly I mean with every factor? When using temporary workers, it's important that the leasing company is in possession of a temporary employment permit. Without permit, it's an illegal temporary employment. And you have to face really high risk, I will tell you in a few minutes. In addition, there must be an employment relationship between the lender and the temporary worker, which allows the lender to lend the employee to another company. Furthermore, and that's quite similar important, you need a contract that is called temporary contract and labeled as such, meaning in German, you need a contract which is called Arbeitnehmerüberlassungsvertrag and not only service agreement. When you don't label it like a termination, a temporary employment contract, it's also illegal temporary employment. Furthermore, the temporary employment contract or in its appendix, you need to identify the temporary worker by name. Moreover, it's totally important to not forget that the length of service for one temporary worker cannot exceed 18 months without a break. When there is no tariff agreement that applies to that temporary worker. And you need to treat the temporary worker equal to your comparable employees.
And just a quick comment, Nina.
Yeah.
I forgot to mention that, but our approach is not to make a comparative approach of various jurisdictions. So Nina's comment might be applicable for Germany, but in some countries, the maximum durations for temporary employment contracts might vary from one to another. So it is important that you verify and you check locally with your local advisor what are the applicable rules. Excuse me, Nina, for the interruption.
You're welcome. No problem at all. So let's discuss a bit more in detail what are the main factors to determine if a freelancer is a freelancer or is probably bogus self-employed. The main points are the freelancer needs to be free to decide what job he wants to take on or he don't want to take on, and he must be flexible in how to do his job. So flexible when it's not part of the task, when, so time and place, and he must be responsible for his work alone and need to be able to financial risks. And he needs to be able to act independently in public, like doing advertisement, like having his own staff, having his own equipment. And what this exactly means, Xavier and Caroline will go in more detail in a moment. But first of all, since I spoke so much about risks here and risks there, let's take a look what happens if the rules I told you before are not observed. And what are the risks here? The risks involve in incorrect and temporary employment and incorrect self-employment is bogus self-employment and illegal temporary employment. What the risks you are facing are quite similar for both. You are facing fines, high fines, up to 500,000 euros per case. And in several serious cases, especially if there is intent and you have for illegal employment of foreigners, imprisonment. In addition, you probably have more employees than you would like to have, because the temporary workers and the freelancers become your employees with all the rights and obligations an employee has. So you are obligated to pay social security contribution for them. They are protected against dismissal by law. They are entitled to continued payment of salary during vacation and illness in Germany. And for the period you took the service of the temporary worker and the freelancer, and if there weren't social security contributions be paid, you are obligated to back payment up to 4 years, and in case of intent up to 30 years. And what you can need to keep in mind at last point, when you employ freelancers abroad, especially when you employ freelancers abroad in a country you have no own business, there is also risk of establishing a permanent establishment with significant tax consequences for you and the company.
So as you can see, even if the rules are not exactly the same from one country to another, what you need to keep in mind is that fines can be significant and risk can be significant. And for temporary workers, you need to make sure that these are fixed-term contracts to replace people or to carry out a specific task. Of course, it is flexible, but you have some risk associated with. Thank you, Nina. So Xavier will speak about the do's and don'ts when managing freelancers, and we will have also Caroline on board for France.
Yeah.
So again, please do not take all the comments we are making for all the countries, but this give you an appetizer of what could be in one country compared to the others.
Well, thank you, Antoine, and thank you, Nina, for your great explanation. As Nina already explained, a freelancer has to act independently, and he can be involved in the organizations of the company. But as Nina also said, there is always a risk that the freelancer will be reclassified by the authority as an employment contract, so as bogus self-employment worker. The purpose of this second part is to try to explain or to list the best practices you must follow to avoid these reclassifications by the authority to the freelancer as an employment contract. So that's why we named do's and don'ts. You have a lot of here example, what you can do, what you do, you can do, what you cannot do. Why? When will the authority may think or decide that you are not a freelancer, or you are not hired a freelancer, but actually an employee? The key aspect of an employment contract is the existence of a relationship of subordinations. That's why on your right, we wrote avoid subordination link. But what does that mean? It depends of a lot of criteria, and the line I had to say the line is hard to draw. A freelancer must act independently, must not be involved of the organizations of the company. What does that mean? That means that he can't receive instructions of the company. But of course, you have to give some instructions to the freelancer when he shall start to work, when the service must be delivered, at what time. So you can give him some instruction, but if you give him too much instructions, then the authority may decide that the freelancer is actually an employment contract. On your right, you have the don'ts. Of course, you don't have to check all the don'ts, but the authority may decide there is an employment contract. If too many don'ts are met, then it will be suspicious for the authority if too many don'ts are effective on your right side. When we say no hourly rate payment, no instruction from a manager, no inclusion in organization chart, no inclusion in the directory, what does that mean? That means that actually the freelancer is part of the company's organized system, is part of the organizations of the company, and then there is a lot of don'ts which are effective, and then the authority may decide, wait a minute, here it is an employment contract. On your left, you have the list what you can do, and of course the first example or the first dose is verify you don't have internal skills. The typical example of a freelancer is someone who has his own know-how that you don't have in your company, in your own company, and to provide the services, he will have his specific tools and software. In this case, there is almost no risk to be reclassified, that the contract, the relationship will be reclassified as an employment contract.
And Xavier, this is real life. We have cases every day where services provider or alleged services providers are trying to recharacterize their relationship into an employment one. Yeah. Today, I have received for one client a decision where a senior executive service provider has tried to recharacterize the relationship. But how should we have distinct email address, or how do we differentiate individuals acting as service provider compared to employees? For example, if you absolutely need them to appear with an email address for your organization, you should make sure that the email address has an external component and that it is renewed from 3 months to 3 months, that the service provider has only access to your IT systems under very specific circumstances, i.e. is not like your employees. So again, the do's and don'ts described by Xavier are very important to reduce and to limit the risk of recharacterization.
Yes, that's true, Antoine. In France, the authorities are very suspicious by freelancers. Then you have here to check before starting with a freelancer, to check two important items or 2 important points. First, you have to check if he is properly registered with the relevant authority of his country, and if necessary, if he holds the necessary license for his business. And the second point, very important, is in France, you have to check that the freelancer is up to date with their tax and social security payments. It is in France mandatory, and if the authorities may require the evidences that you have checked that he is up to date with the social security contributions. Actually, the aim of this check is to prevent the use of subcontractors who do not pay their social security contributions, and which allows them then to make a very competitive offer with very competitive prices, because of course he don't pay social contributions. That's the aim of the authority, as they are very careful about this fact. And the third one is a recommendation, but to check that the freelancer has a valid insurance and risk coverage if in case of damages, or if you want to require this contractual liability. So the third slide wants only to focus on when you want to hire some non-EU freelancers. Of course, you have to check that if he comes in our country, he has a valid permit, a valid visa, sorry, and a work permit. Don't forget that it's the same with the freelancer from the UK now. And you have to check also in the case that the freelancer is working remotely from non-EU country, that he has or he does require a local establishment or registrations. And we'll say in all cases, verify also. You have to verify also if the freelancer needs to be registered as self-employed locally, or if there are tax obligations locally, or perhaps on almost cases a double taxation agreement. But just may I ask to Caroline if she wants to add something with a case she faced for other clients?
Thank you, Xavier. Yes, I'd like to point out that in France, it's not enough for the company and the independent contractor to agree on working as independent contractors. What really means is how the relationship works in practice. The Social Security inspector has the right to review the situation, and if the legal criteria are not met, he can reclassify the relationship as a salaried employment. And this is because in France, you cannot choose your employment status, but it's something of public policy. And be aware that in addition to civil aspects, the judicial police also has the right to organize hearings with the management. And in the case that I handled, the criminal procedure turned out to be helpful to my client because the strict rules of the criminal procedures were not properly followed by the Social Security inspector, which led to the cancellation of the reclassification. This is just what I would like to say today for our webinar. Thank you, Xavier.
So do not forget that the type and the name of the contract is not a sufficient protection. You need to verify that in the real life, freelancers are really free. Thank you very much, Xavier. And I think we are moving to Italy and Luxembourg with Marco, Ottavio, and Rafael.
Yeah, thank you very much, Antoine, and thanks to my colleagues. Moving on, it's actually going back to our case study. We said before that in our case study we are considering a chief human resourcing hiring or employing various individuals through different forms of contract throughout Europe. Aside from to the freelancers, there is another way of, let's say, using staff that is becoming more and more common in Europe, and is a service offered by the so-called employers of record. What is an employment of record, first of all, and then let's see why it's becoming more and more common, even sometimes more than using a freelancer. First of all, an employment of record, for those who are not familiar with this terminology, is a company that essentially provides a foreign client with the necessary staff in one country, in our case in Italy, of course, by employing them directly and paying taxes and social security, being their formal employer. So what usually happens is that if we have a group, as in our case, that does not have yet a presence in Italy as a legal entity or a branch, they usually prefer, instead of hiring the individuals directly in that country, to let's say have the employer of records hiring these people and then providing them the service. So basically, this is an activity which is very similar to the activity of provision of manpower, which is a service provided by a temporary agency, usually like ADEC or Manpower. And we have to be very careful with this kind of service, because in Italy, but as in most European countries, this kind of activity is strictly regulated by local laws, not only by European directive, but also by local laws, and there might be some risk. Of course, an employment of record does not only provide staff, it provides a lot of services, but here we are focusing on this potential risk. So basically, the employer of record hire the employee, and de facto the employee works under the direction and instructions of the final user company. In this case, as I was saying, we have to be careful because this is an activity. Next slide, please. This is an activity that has to be previously authorized by the Ministry of Labor. And since most of the time, so at least in our experience, employment of records include this service among their services without having the necessary authorization, there might be some risk for the final user and of course for the for both companies, the EOR and the final user in particular. First of all, there is the risk that this activity is reclassified by local authorities as an illegal or unlawful provision of manpower. And this would give rise to sanctions. Well, in Italy in particular, these are the sanctions ranging between a minimum of 5,000 and a maximum of 60,000 euros per contract. But also, the EOR formal employees might be considered as the client's employees. So they may ask for being reclassified as employees of the final user, and the final user would be asked to pay Social Security contribution for them, which hasn't paid so far. And also another thing that we are experiencing in our day-by-day activity is that sometimes the user needs to dismiss someone for redundancy. And in this case, it's difficult because the reason would be the redundancy among the user organization. But the EOR should issue the dismissal letter, making the comparison between its own employees. So we have basically a separation. We have a rationale that doesn't fit the EOR activity, the EOR business. So when the EOR issues the formal dismissal letter, in reality, we notice that we have the problem on how to justify this redundancy. And of course, this may be a big issue when coming to a termination of employees hired by someone else. I leave Marco recap and summarizing then what are the tips and traps for this particular form of service.
Thank you. Thank you, Ottavio, for your remarks. They are very important in order to evaluate which are the main rules in Italy ruling this important sector. Now we will see which are the recommended approach and consideration when using an EOR. Of course, the first suggestion is to avoid using an EOR without a proper license. So it is very important to select an EOR duly licensed and equipped with an appropriate experience and competence in this sector. We know there are a lot of competitors in this sector, especially in Italy, but across the Europe. So it is very, very important to select the most important and experienced ones. The second important suggestion I would like to share with you is, if possible, if it is evaluated that the possible use of EOR may lead to some criticalities and issues, it is suggestible to prefer the direct employment by the final user competent. even when there is not a legal entity duly registered in Italy. For example, when there is a branch located in Italy, it is enough for the workers to be directly hired in Italy. And of course, in this case, the employment relationship will be ruled by Italian law. Another important suggestion, in my opinion, is related to the possible, if any, tax and the social security contribution risk that may arise in relation to the permanent establishment. We know that even if this topic is not directly related with our intervention, it is very important to previously assess whether the use of an EOR or other similar forms of hiring personnel may lead to possible risk and issue related to permanent establishment or similar non-compliances with the tax Italian rule and with the social security Italian rule. Now, thank you for your attention. I leave the floor to my colleague from Luxembourg. Thank you again.
Thank you very much, Marco. Thank you also, Ottavio. My name is Raphael Schindler. I work for Lutin in Luxembourg. I'm also an expert in employment law. And I will talk to you a little bit more about my jurisdiction, just so that we see another example, Luxembourg. I will try to take a slight step back because you will see what I am going to tell you will go back to actually what Nina already explained and what Ottavio also explained. So just to take a step back, I think it's very important from a legal perspective to understand how the legal regulation works. And that is, you have one principle, one big principle, and you have exceptions to that principle. It sounds a little bit naive when I put it that way, but it's really important to understand that you can fall within the scope of an exception, and then you are in the exception, of course, and you benefit from that exception. But if you don't fall exactly within the scope of an exception, you fall back into the principle. And in the case of the specific topic of EORs and then more generally speaking, umbrella companies and such mechanisms, the principle is that the loan of labor is prohibited. That's something that we know in Luxembourg. That's something that's also very common in other jurisdictions, of course. What does that mean concretely and legally speaking? Well, in Luxembourg, it means that you have consequences on the contracts. First of all, the contracts that you think would exist between the lending employer and the employee can be considered as void. And to the contrary, you can have an employment contract which exists, which you did not expect, but which exists between the user company and the employee. And specific thing in Luxembourg, probably also exists in other jurisdictions, is that the employee, but only the employee, has a right to terminate this, I would say, newly existing employment contract, and without notice or any compensation. Then another consequence is that, as I said, the lending employer, the employment contract that you thought existed between the lending employer and the employee does not exist anymore. But still, the lending employer and the user company are to be considered as jointly and severally liable for the payment of all wages and, of course, social security and taxes. And on top of those legal consequences, you also have through criminal sanctions, fine up to 24,000 euros, even imprisonment 6 months. And those sanctions are per concerned employee. So, of course, if you use a certain mechanism with a number of employees, and in the end, it turns out that you are not within the scope of an exception, but you are really in the scope of the principle, which is the prohibition of the loan of labor, it can become quite expensive. We can switch to the next slide, Antoine. Thank you very much. So now a few words about the exceptions, because I just described the principle, but in Luxembourg law, basically there are two main exceptions to that principle. The first one, which is the column on the left of this table, it's what we call temporary loan of workers. In practice, in Luxembourg, it's often within a certain group of companies. It can also be in circumstances where there is an imminent collective dismissal or there is some underemployment by a company. And in such specific situations, a temporary loan of workers can be allowed. But this, it's important to say also, it's always subject to authorization by the Luxembourg Minister of Labour. That's the first exception. Then you have a second exception, which is temporary work, which was already described also by my colleagues. It also exists in Luxembourg. And it's interesting because, Antoine, you were mentioning that some mechanism can exist in one country, in one jurisdiction, and also in others, but there might be differences. Here, I believe that Nina explains that for Germany, it was a maximum limit of 18 months, if I'm not mistaken. Well, for Luxembourg, the limit in time that applies to temporary work is 12 months. So that's an example of a slight but important difference between the way that different jurisdictions approach one same mechanism. What's important to note or to understand is that temporary work, well, the title says it all. Basically, it's only meant to be temporary and it's only meant to be for specific work assignments. So it's not meant for general or permanent tasks. You cannot use this mechanism for that, only for specific tasks, limited in time, again, maximum 12 months in Luxembourg. And this is important, only with temporary work agencies which are duly authorized by the Minister of Labour. That's very classic among most jurisdictions, I believe.
And what
Then the
about
question,
EOR and umbrella company, Raphael? Is it authorized in Luxembourg?
That's a very good question, Antoine, and that's actually the question which I've had to deal with personally, I would say, for a client, of course, a few months ago. The question is, EOR umbrella companies, you are not strictly speaking in the scope of temporary loan of workers or of temporary work, but it's kind of similar. So you could think that it would be allowed. And what's very interesting, which I saw myself working for this client a few months ago, is that in Luxembourg, you will find many websites, many internet sites from companies which do actually promote EOR or umbrella companies for work to be done in Luxembourg. You find that, you search on Google or any other internet search tool, and you find such websites. And so you'd expect that this is all allowed and perfectly legal and that there is no issue at all. But actually, when you take a closer look, no, it's not. And there has been some case law here in Luxembourg about this. Specifically with regards to umbrella companies, which in French we call portage salarial. So it turns out that umbrella companies and the use of EOR are prohibited in Luxembourg because you don't, these mechanisms do not fall within the scope of the strictly regulated exceptions, which are temporary loan of workers and temporary work. So you fall back to the principle, which is the prohibition.
Thank you, Raphael. And as a difference, we can say that portage salarial or umbrella companies are authorized in other countries. So please do remind that what is legal in one country may not be legal in another. So thank you very much, Raphael. Nina,
Exactly.
do you want to jump in?
last but not least, I want to inform you a bit about the EU directive on platform workers. Before this, I want to stress that what my pre-speaker said is really very important. And I just recently discovered that there is not only the concept of EOR, but also of COR, which is contractor of record, and which is also an interesting phenomenon. I'm dealing with this with a few clients at the moment who have the idea that this is a brilliant idea to avoid classification as employment relationship, which I doubt. So I do have my doubts on both EOR and COR, but just that you have heard of this concept of COR, it exists, and I think it will come more and more because companies are and this is very good, very creative, and try to find new business models. But back to my part, you might have heard of the EU directive on platform workers. It actually came into force in December 2024, and the member states now have 2 years, so until 2nd of December 2026, to implement this into national law. So from now, about 1.5 years. And since it's a directive and not a regulation, it must be implemented by the member states. To date, no member states has effectively implemented the directive into national law, probably because most of them are still wondering in which code and how they exactly do it. The European Parliament has become a bit nervous, it seems, because they launched a monitoring group just recently, about a month ago, to further advance the implementation of the directive, and in order to ensure that by December 2026, the member states have implemented it. First, and good news maybe for most of the participants to this webinar, the EU directive on platform workers applies to operators of digital platforms. It does not apply if you as a company or you as a private person consume the service of platform workers, then this is nothing you have to think about, but it does apply to operators of digital platforms. And I think that this, because I don't know yet, but there will be a very broad interpretation of operators of platforms. What are the current cases, or where did this come from? It comes from platforms you probably all know, like Uber Eats, and then it depends on each country. I asked my colleagues Glovo in Italy, for Austria and Germany, TaskRabbit, Deliveroo in Germany and France, Lieferando in Austria and Germany. So probably you better know than me which digital platforms you have in your countries. And as you might know, there have been a lot of court cases going on the rights of these platform workers. This is a new wording, and the EU directive now aims to protect the rights of these platform workers. The 3 main principles of the EU directive, just that you are briefly informed, the directive wants to combat false self-employment through the rebuttable presumption of an employment relationship. Furthermore, it wants to be very clear on what is allowed and not allowed in algorithmic management. What is meant by this? It's meant by this that a lot of AI is used by the platforms to control, monitor, and organize the platform workers. And in order to regulate this, it has now rules that the platform operators must observe. And thirdly, it wants to increase transparency to platform workers so that they know more about what they do, when they do it, on which basis they do it, and how they are protected. So on this rebuttable presumption of an employment relationship, which is key to the EU directive, it basically means that if, and this is very simplified, but just to give you an idea, this means that if a worker is directed and controlled by the platform operator, there is the rebuttable presumption that there is an employment relationship between the platform operator and the digital worker. So it's not an independent contractor or something else, it's an employment relationship. If the platform operator says, no, that's not true, it's not an employment relationship, then it's for the platform to prove that it is not an employment relationship, that there's no direction, no control, etc., depending on all the criteria that Nina mentioned at the beginning of our webinar to distinguish between independent contractors and employees. And the directive says that the member states, of course, must establish effective procedures to verify the correct employment status. So let's see how this will be transformed into the national laws of the member states. Another important thing is the regulation of algorithmic management, and this basically means that the platforms will have to be much more careful which AI they use. They have to be more transparent to the platform workers, and they must really be careful on using everything connected to algorithmic management, especially AI. And on the transparency, this is also important to know that the platform operators will have to provide a large amount of information to the competent authorities. So far, it is not clear which competent authority will be the competent authority in each member state, but this will come from the member states, and the competent authorities also can request more information and also see if everything is complied with. Should you or any of the persons you know have platforms or operate platforms, then please make them aware that this directive is there already and needs to be implemented until December 2026. And I guess that also for lawyers advising workers, there will be a huge new large amount of work. So thanks, and over to you, Antoine.
Thank you very much. Thank you to all participants. We have 5 minutes for questions if you have. So you can see it's important, even if we are operating and you are operating in a global environment, it is still important to consult with local experts. And we have the chance here at unyer to have a marvelous team with fully qualified lawyers in employment law, and we are used to working together on international projects. So make sure you have internal competences and skills. I recall that all the principles that have been explained by my colleagues may also apply in a group environment. A loan of workers is not only prohibited with external third parties, when it can be illicit even in a group when you invoice the loan of workers in some countries, because when it's paid and when it's remunerated, it can be illegal. So free loan of workers might be authorized in France, but might be unauthorized in Luxembourg. And at the opposite, when you impose a markup to one company to another out of a services agreement, it can be questionable. So make sure you have the right approach, and you can question what is deemed to be obvious for you. Okay, and even if it exists since years, do not hesitate to ask questions. Is it illicit? Isn't it the right way to do it? In some countries, it might not be possible for an international employer to directly hire an employee, but in some others it's possible, and it might be the only solutions. So make sure you have the right approach and you have the right advice.